All right, I have an incredible think tank joining me tonight. With me, the Honorable Phyllis Collins is here, criminal defense attorney Brian Watkins is here, and criminal defense attorney and former prosecutor Marcia Minot is here. Great to have you three on the program. Can't wait to pick your brains about this one. This woman back in court again today, an amended criminal complaint, not homicide charges. I want to go around the horn, if I can, please. At first, just get your quick reactions to this big breaking news today. And Judge, I'll start things off with you.
Well, the walls are really closing in on Lori Vallow, and truth is stranger than fiction. This story is just bizarre and keeps getting more and more bizarre every day. I'm thinking her only option at this point is probably going to be not guilty by reason of insanity. So I think she's needs to be looking to make a plea offer at this point.
Gotcha, Judge. Thank you. Brian Watkins, give me your reaction, please.
It's funny that she's not charged with murder because she's charged with concealing evidence of a crime. That crime is murder if they're saying that the bodies are the concealed evidence, but there is no murder case. So that's a unique case. You normally don't see the defendant, whether they get on a high-speed chase and run from the police, getting charged with, destroying evidence. I mean, that's what defendants do. They should charge her with the substantive crime, which is murder.
Brian, thank you. Marcia Minot, last but certainly not least, give me your reaction, please.
Coming from the prosecutorial mindset, I would think that murder charges would have already dropped. A lot of times what you'll do as a prosecution is you'll charge both individuals with murder, even though you're still in the investigatory stages and are unable to determine who is actually responsible for what. That sometimes would cause one of the defendants to at least become a state's witness and start telling you all the truth and all the evidence that you need to get a conviction on both of them.
Marcia, thank you. All right, let's dig a little deeper, if we can here, to these overt acts in furtherance of a conspiracy. We know the state has to prove these in a court of law beyond a reasonable doubt, and that affidavit lays these out for us, and we've got them here. I want to show them to you at home. And first up, telephoning Melanie Gibb, asking her to lie to police about the location of JJ, asking Gibb to create false evidence of JJ's existence and location, falsely informing the Rexburg police that JJ was in Arizona with Melanie Gibb. That's CULTMOM's BFF, former BFF, I should say. Falsely informing the Rexburg police that Ty Lee was attending BYU, Idaho, and living with Vallow, and refusing to produce the children to the Rexburg police or the Idaho Department of Health and Welfare as required by court order. So the last point there, point E, the last overt act alleged by the state we know was what she was being held on before today, right? Those were the charges of desertion, failing to produce the kids, all of that. But those charges just couldn't stay, right? Because the police produced the kids. Brian, I want to tap into your criminal defense attorney experience, if I may. If you were given the job of defending CULTMOM, what are you thinking today? Learning this new information and all these overt acts, how do you go about defending her?
Well, you take the position that I have the right to say, hey, cops are coming around asking questions about me. I can tell my friends and family, hey, you don't have to cooperate them. You don't have to speak with them. I have that right. And I would make the position, that's all that I did. I did not, have evidence in my hand and destroy evidence. Evidence of what? There's not even a murder case. So you're trying to say that I'm destroying evidence of a murder case when there's not a murder case. So I think she actually has a good leg to stand on as far as these new charges are concerned. I think she'd have a weaker leg to stand on if they ever brought murder charges.
That's a great point. Marcia, what do you think about that? Do you think, let's just say we get to the point, for the sake of our analysis tonight, that murder charges are filed against CULTMOM, and let's say that Mr. Doomsday, her hubby, is the co-defendant. What do you think about the case? Do you think we're going to have as strong of a case as investigators have now, maybe stronger? And what do you think about the fact that old Uncle Alex is alleged to be a co-conspirator and he's dead? So might they point the finger at him?
Well, the state used the word others in the amended complaint. And the fact that you're using others is stating that you may have other individuals that are involved that you're not aware of at this point, not just the uncle who is deceased. This case is going to get a little bit more bizarre as we go forward, because we're going to be able to find out as the state gets to the crux of the case, who was engaged in what, who killed the children, who actually buried the bodies in the backyard on the property. And I believe these underlying felony counts are probably necessary in order to go forward with a felony murder charge.
Marcia, that's a really, great point you made there. Yeah, you wonder if there are more co-conspirators. I mean, we've been focusing a lot on Uncle Alex, and there is a lot there with him, and this whole plot just seems so sinister and sick. But you made a great point. Maybe there are more. Maybe more folks in this family possibly were partaking in these events. Judge, I want to go to you on something that was discussed today. The judge presiding over this case was asking Mark Means, the defense attorney who represents Lori Vallow, if he's represented anyone else involved in this alleged conspiracy, and he answered no, and the prosecutor piped up and said, well, actually, yes, he did represent Mr. Doomsday early on before he was charged. And so there was a little bit of a dispute, but I want you to talk to us, please, about how cognizant the court has to be about safeguarding the rights of these two defendants, and if they are bold enough to maybe want to try this case together and not have their cases severed, what the judge has to be aware of and possibly do to make sure that this is voluntary and isn't going to come back on appeal.
Yeah, the court has a duty to inquire about any potential conflicts. And obviously, this attorney sounds like could have a potential problem here because these two could be in direct conflict with each other. They may not be right now, but you don't want to get a year down the road and then all of a sudden now one turns on the other one and now they're in conflict with each other and the attorney has been privy to information that could hurt his client. So I think that the judge is right to make this inquiry now and go ahead and get it on the record and get it out of the way.
Right. Yeah, that definitely was put on the record today, and he said it seems like there's a bit of a dispute, so hopefully this will be clarified. Quickly, Judge, tell me, do you think these two defendants are going to want to go to trial together? If, let's say, they're both charged with homicide, do you think they're going to want to just team up and have the Doomsday defense?
I think possibly so, particularly if they're going to try to pin it on Alex. It sounds like maybe Lori might be in a little better position because they haven't said anything about her cell phone records being tied to the property. Obviously, Alex's cell phone record indicate that he was there, and probably Chad's are going to indicate that he was there as well. So he may have a little bit more trouble with pinning it on Alex, but I think Lori could be in a position that she could use that as a good defense.
Gotcha. Judge Phyllis Collins, Marcia Minot, Brian Watkins, great to have you on the program tonight. You're going to stay with us, and we want you to kindly stay with us at home as well. Have to take a commercial break. We'll be right back, and we're going to turn our attention to a big case happening in Atlanta, Georgia. The officer accused of felony murder for the shooting death of Rayshard Brooks was in court today, and he was given a bond. We'll discuss it right after this.
Do not believe that he is a danger to the community in the sense that Ayala sets that forth. I do not think that he is a danger of posing any significant risk of committing an additional felony pending trial. I do not believe that he poses a significant risk of intimidating witnesses, but I will talk about that. And I am therefore going to grant a bond.
Okay, fired officer Garrett Rolfe, given a bond of $500,000. He's accused of felony murder, facing 11 charges in all for the shooting death of Rayshard Brooks. That's the case that happened in the Wendy's parking lot in Atlanta, Georgia. And we reached out to one of his attorneys. He's represented by two attorneys, and Noah Pines is one of them. He's a familiar face. You've seen him here on Court TV Live before. We reached out to Noah tonight to ask him about the bond, and this is what he said. He said, quote, "We are happy that the judge thoughtfully considered all of the appropriate factors and granted Garrett a bond. Noah H. Pines and Bill Thomas is the other attorney. Now, part of the conditions attached to his bond, he has to wear an ankle monitor. He's got a curfew of 6 p.m. to 6 a.m. He has to turn over his passport. He's not allowed any firearms, had to relinquish all his weapons, and no contact with any witnesses or with Atlanta police. And this is going to be part of my next question for the members of our think tank. I want to bring back in Marcia Minot, Brian Watkins, and Judge Phyllis Collins. So something that the prosecution wanted, Fulton County DA Paul Howard wanted wanted Garrett Rolfe to turn over the password to his cell phone, because he said that there was evidence that he engaged in several different text message conversations with Atlanta police officers shortly after the incident, which would be understandable. He was an Atlanta police officer. And now the court did not require him to turn over the password to his phone. So want to make that clear. Court did not require that. I just issued a reminder that he and his counsel have to be aware they can't alter, disturb any evidence contained in that cell phone. So I want to ask your thoughts on that and really tap into the criminal defense experience that you all have. So just want to go around the horn. Marcia, I'll start with you. What do you think about that, wanting the password to his cell phone to get at those text message conversations after the incident at issue?
You might be able to get to those cell messages, however, not at a bond hearing. The court is limited in what it considers that bond, and the court went through what that was, which is flight risk, threat to witnesses, a risk of fleeing the jurisdiction, whether you're going to commit additional felonies if out on release, or witness tamper or evidence tamper. Now, the state probably was asking for that because they were concerned that this officer might be engaging in evidence tampering by removing anything that would incriminate him from that cell phone. So they can get to it in the future, but usually at a bond hearing, that's something that's not addressed without a search warrant.
Very good point. So not an issue for today. But if it does become an issue down the road, Brian, I want to go to you next, please. Let's just say, for instance, the state is really pushing for this. What do you do as defense counsel if you represent Garrett Rolfe? What do you do to try to make that argument that this is his personal phone and the state doesn't have a right to go in and try to extract personal cell phone messages?
They're going to need to get a search warrant. And the basis for a search warrant is that they have probable cause to believe that evidence of a crime will be located there. Now, you don't get to fish around and search for evidence of a crime. You have to have clear and articulable facts that I know that if you let me look here, Judge, there will be evidence of a crime. I don't know if they're going to have that basis. I mean, there's a chance. I mean, in everybody's cell phone, there may be something incriminating. There's a chance that he said something incriminating on a text message to someone, and there's a chance that he didn't. But the question is what probable cause do you have? What clear and articulable facts can you say he did, in fact, send a text message that is incriminating, rather than this being a fishing expedition? So if they file that search warrant motion, I'm absolutely attacking it.
Great points there, Brian. Let's listen together to a clip from the hearing today, and something that was perhaps somewhat unique. Every state does it differently, but here in Georgia, there can be testimony from affected members of the family, victims, if you will. And today, the judge heard a little bit from Tamika Miller, who is Rayshard Brooks's widow. It was really heartbreaking. Let's watch.
It's only been a few weeks since my husband been gone and murdered. And just the week before I laid him to rest, my daughter's birthday was that week that he was killed, and my anniversary was the next day. It was the next day. Father's Day came up. Our wedding anniversary was on the 14th. My life has completely turned upside down since this has happened. I've been unable to sleep, eat, or even console my children. But I feel today the court wants to be able to let the defendant bond.
Ma'am, could you say that again?
The defendant, you guys want to be able to give a decision whether he should be able or allowed to bond. And I say no to it. I say no.
I don't know who could watch that and not have their heart breaking listening to her. But taking a step back and just looking at the legal factors that the court must consider, Judge Phyllis Collins, want to bring you in on this. Emotion really has no part in it. And I want you to sort of lay out for us, if you will, the factors that every judge has to consider when granting a bond. And also going back to the 8th Amendment in our Constitution and how bail must not be excessive.
Right. So this is really difficult for victims who have been traumatized and lost family members. It's really difficult for them to understand that the judge does have to follow the 4 criteria, which are the risk of a flight. Is the defendant going to flee from the jurisdiction? The threat to the public. Do they present a threat to anyone in the public? Are they at risk of committing a new felony? And then are they at risk of obstructing justice? And if all of those factors are met, then bonds should be set. And in this particular case, that was appropriate. So I know it was really tough, and I thought that she was very gracious about expressing her discontent of the bond, but also understanding that that was probably what was going to happen.
Sure. Well said, Judge. And, as far as, I guess, what happens next in terms of this case and going forward and reviewing all the evidence? Let's talk about both sides here. Marsha, I'll have you take the position of the prosecution and Brian take the position of the defense, if you will. What do you think? Give us an idea of what both sides are doing. I mean, this is a case where everyone's eyes are on it across the country. People are interested in the outcome. Not an easy case by any stretch. Talk to me about the preparation. Marsha, I'll start with you, please.
Part of your preparation is to make sure that you're gathering the evidence of the circumstances that occurred that night. That would be, was the police officer excessive? Where was the victim when he was actually shot? How far away from the officer was he? Was he actual threat to the officer? Because cases where the perpetrator is an officer and the victim is a civilian are tough cases, because there's a tendency to think it's a tough job. The police officer has to make it home to his family. So you kind of have a bias in favor of the officer. And as a prosecutor, you're going to have to make sure that you're ready to overcome that bias and emotion with evidence.
Marsha, thank you. Brian, talk to me about the defense standpoint. You're no stranger to high-profile defense cases.
I focus 100% on the dead guy, Rashad. I put all of his actions on trial. That's what I do. I say, what is this guy doing? Why did this turn out this way? It's because of his actions, not because of the officer's actions. Rashad Brooks controlled this situation from the beginning until the end. My officer, my defendant, did what he had to do. So I focus completely on Mr. Brooks. And it's a sad thing because, he's dead. But the problem is that he also can't defend himself. So I actually capitalize off that.
Brian Watkins, thank you so much. Marsha Minot, Phyllis Collins, thank you both. I want you to stay with us at home. Our think tank is coming back, analyzing the next case we've got for you. This one involving New England Patriots owner Robert KRAFT. An appeal in the case. We haven't even had the trial and we've got an appeal. We're going to explain. This is all about covert video surveillance done inside that day spa in Florida. We'll talk about it and get your reaction on social media too when CourtTV Live continues. Oh, so the big question, which way is the court going to go on this issue of whether that video evidence comes in? I want to bring in my think tank, pick their brains about this, and just to kind of set the scene here, the trial hasn't happened. And so there was this issue about the video evidence coming in that was litigated. The trial judge said, no, it doesn't come in. The prosecution appealed, and this 3-judge panel heard these arguments today from both sides. And so we're waiting on that decision, but I want to get your thoughts. What do you think about this? This is from a sneak and peek warrant in this day spa in Jupiter, caught lots of defendants. So this decision is really far reaching. And Judge Phyllis Collins, I'm going to go to you first. What the court decides here, whether to let this in or not, is going to affect not just Robert KRAFT's case, but all the other defendants who were charged as a result of those cameras in the day spa. So lots of cases go bye-bye if this video evidence is excluded. Your thoughts?
Well, and also the stakes are going to be high for the police because they like to be able to use surveillance evidence, get search warrants to conduct surveillance to solve crimes. And so you've got a big constitutional question here because you've got what is your expectation of privacy versus what's the state's interest in reducing crime. And so those two interests are at odds here. And so I think it's more likely that the appellate court will uphold what the lower court says. But there's going to be lots of folks that are going to be disappointed in that ruling.
Definitely. Marcia, talk to me about privacy rights and the Fourth Amendment, if you would, please. Now, remember, this video evidence was captured not just defendants who were charged ultimately, but people who were having massages, people who took off their clothes and had their massages and didn't break any laws, but yet they were caught on camera because this warrant was pretty far-reaching. Your thoughts?
I think that's the issue that the state has with this. There's a doctrine called the fruits of the poisonous tree. And if you've gathered evidence and some portion of that evidence is gathered unlawfully, then you have a problem, because what the courts are going to have to decide is whether they're going to throw out all the evidence that you've gathered. The problem you have here is that the scope of the warrant was exceeded when the state decided through its law enforcement officers to record innocent individuals who were present and just getting regular massages. So I do believe that the Court of Appeals is going to affirm the trial court's decision and ruling to exclude the evidence, specifically because of how it was gathered and it's connected to evidence that was gathered unlawfully.
Marcia, thank you. Brian, talk to me about this from a defense perspective. Let's just say you're representing Robert KRAFT in this case. What are you going to argue to the court after you already won on suppression? Suddenly the prosecution takes an appeal. You find yourself back in court in front of a 3-judge panel to try to relitigate this. What would you say about it?
Well, of course, the lower court absolutely made the right decision. This is despicable conduct by the prosecution, because they had to have lied in that affidavit. To get a search warrant, that affidavit has to state under penalty of perjury that there are no more less intrusive means other than this surveillance. And clearly we know that's not true. They do sting operations all the time. All they do is send in an undercover to be a patron and then catch the people in the act. That's all they have to do. But they wanted this video to even record innocent people. And the Fourth Amendment and the exclusionary rule, what it protects is innocent people. We, the innocent people, are free from unlawful searches and seizures. So it's an outrage that women that were there to get a massage were filmed as they were undressing. And in fact, if I found out who those patrons were, I would contact them because I would file a lawsuit for a violation of their Fourth Amendment rights. They've already admitted that they did it, so it'd be a slam dunk lawsuit on my behalf.
Excellent points, Brian. And to take a step back, we know that initially law enforcement was going in there because they were suspecting human trafficking. So that's what this case was supposed to be about. But at the end of the day, nobody's charged with human trafficking. And that came up today in the hearing. Let's take a listen to a clip. We hear Attorney Derek Schaefer speaking. He's one of the attorneys representing Robert KRAFT. Let's watch.
How much credibility or credence or emphasis, though, do you put on the notion that the state argues that they legitimately thought we had some human trafficking going on here? What about that?
Respectfully, Judge Sicklin, I give it no credence. I give it no credence. It was innuendo and it was smoke. In the warrant application, there was no claim that human trafficking was being investigated. That's not among the offenses in the warrant. The only offense that is specified is derivation of proceeds. And the moment the state came into court at the trial level, they said that the videotapes here could become public because the statutory exception that would apply in Florida if there were any suspected victims of human trafficking was categorically inapplicable. They knew that this was never a human trafficking case. Law enforcement knew it. The issuing judge knew it, and every judicial officer who's touched this case knows it. And in fairness to Mr. D'Souza, I don't hear him claiming that there was a serious interest in investigating human trafficking here. To the extent there's any suggestion of it, it was borrowed from another county. It was copied and pasted.
Oh, Judge Phyllis Collins, if you heard that attorney making those arguments in your courtroom, what would you think about that?
Very compelling, and we didn't hear the rebuttal to that. So, but very compelling evidence, and that's why I said I think you're going to see the appellate court is going to go ahead and side with the trial court judge.
Thank you. And Marcia Minot, you've got experience on both sides of the aisle. You've served as a prosecuting attorney. You practice criminal defense now. I want you to take the position, for the sake of our analysis, of the prosecution and having to rebut that argument. We just heard from the defense attorney about the fact that there was no credence to this, essentially that this was a fishing expedition. What would you say if you were the prosecutor and had to respond to that panel?
If I'm prosecuting, I would argue to the court that we did go in there for one particular purpose. But fortunately or unfortunately for the defense, sometimes, Judge, when you go in to do surveillance for one particular reason, other crimes will sometimes surface on your videos. And if other crimes surface, you have a duty as a prosecutor and as the state to pursue them. You may not have gone in for that reason, but if the crimes are surfaced as a part of your investigation, then you have a right to prosecute them. So we're asking you, Your Honor, to not exclude the entire video, that we can modify the video and we can redact the portions that include any innocent individuals that were getting massages. We'd ask you to go forward and allow us to present it to the jury because they're crimes that were committed.
Marcia, thank you. Brian, I want to go to you about the resolution of this case, if I may, please. And of course, we're not privy to any plea offers, if there have been any. But Robert KRAFT, 79 years old. These are 2 misdemeanor charges. I used to serve as a prosecutor for a time, and I'm thinking to myself, what would I do that would be reasonable? Maybe something like some kind of resolution, maybe go to something in the city of Pittsburgh. We had something, John's School, where we would say, hey, go to some classes, do some community service, come back, and we're going to withdraw these charges. What do you think would be reasonable to resolve something like this? Or would you fight it regardless of what the state might offer as a plea deal?
Absolutely. I fight it all the way, because you got to look at the case. How is placing a video camera in a room where someone is going to undress and get a massage, how is that going to show human trafficking? What do you expect to see on that video? How would you see human trafficking from a video like that? It was outrageous that they did this. It's misdemeanor charges. The standard plea deal, not actually plea deal, but the standard punishment for this crime is community service and a fine. They're looking at spending hundreds of thousands of taxpayers' dollars to get Mr. KRAFT to do some community service and pay a small fine. It's outrageous. And I would not take a plea deal. I would fight this case all the way.
Appreciate it. Brian Watkins, Marcia Minot, Judge Phyllis Collins, thank you all. You're going to stay with us. And of course, I want you to stay with us at home, because when we come back, the 13th juror speaks. We've been getting your comments today on social media about this case and that covert video surveillance. We'll see what you think after the break.
The arguments that these defendants have proposed are, well, the Constitution required that they minimize women. But the problem is, all of these defendants are men. And so even if law enforcement had completely ceased recording women, Mr. KRAFT, Mr. Brophy, Mr. Friels, they would still be before you. You would still have that evidence sufficient to convict them. The same is true of their claim that, well, look, police should have minimized when a man left on his underwear at the start of a massage. Well, these defendants didn't leave on their underwear. Mr. KRAFT removed his immediately. His first massage was on day 2 of the operation. He took his off immediately. Apparently, that's an indication that he's going to pay for sex. So we were authorized to film that.
Welcome back. We're continuing the conversation about the covert video surveillance in Robert KRAFT's prostitution case. And it has become our 13th juror question of the day today. So we're going to get to your responses right now. First up, we have our comment of the day. Coming to us from Marge Reese. Marge, thank you so much. Marge says, quote, should it? Nope. Seems a bit entrappy for me, but he can afford it. Yupper. He should have utilized a different type of service. You get what you pay for. Cheapskate. All right, want to bring back in my think tank. Brian, I'm going to go to you. What do you think about Marge's comment here? Do you agree with her?
Well, we wouldn't even be talking about this case, and they would not have appealed this case if it weren't for Robert KRAFT being a defendant. If it was just Joe Schmo, which is happening all over multiple states, this case wouldn't even be, a topic, nor would they spend the money to prosecute it, let alone appeal it.
Gotcha. Appreciate it, Brian. Let's go to the next comment if we can. This one coming from Ed. Ed says, no, although it may help the prosecutor, it will infringe upon the right to privacy for many others. Marcia Minot, what do you think about Ed's comment? Do you agree?
I agree. It's going to infringe on the rights of the individuals who were just going into an establishment to get a massage. It is a misdemeanor count, and I don't think it warrants this type of taxpayer resources or scarce judicial resources to go after.
Gotcha. Appreciate it. Next comment from Yoli, and we appreciate all of you submitting your comments. And Yoli, thank you for this one. She says, quote, wow, Pops was enjoying himself. He paid for it. Why not? Guilty feet have no conscience. He committed a crime. Then he must suffer the consequences. Judge Phyllis, what do you think? Do you agree?
No, the problem here is that people are going to say, you know, that because he's got a lot of money, he's getting away with bad behavior. But again, this is a constitutional issue, and the price that we pay for ensuring protecting everyone's constitutional rights is that sometimes guilty people get away with what they've done. And I think that's going to be the case here.
Appreciate it, Judge. Next comment, and I really like this one. This is from Lisa. She says, quote, no, that is such an invasion of privacy. To watch someone in a spa is the same thing as watching customers in a gas station when they're in the public bathroom. What a good analogy there, in my opinion. Brian Watkins, what do you think? Do you like that analogy as well?
I do, and like I was saying before, the Fourth Amendment right against unlawful searches and seizures protect the innocent. So that's what this law is about. And when the cops break that law, their punishment is they don't get to use that evidence. That's why there's an exclusionary law, and the fruits of the poisonous tree. If it's poisonous, you don't get to use it. And that's exactly what we're talking about here.
Exactly. Going back to it, Marcia raised that doctrine. We're learning a lot tonight. You all are wonderful, lending us your expertise, and this is educational. It really is. And I want to try to get some more comments in. So let's go to Judy's comment. She says, quote, I think it should. It is evidence that the crime happened. Nobody should be above the law. Unfortunately, in this country, money talks. He'll get a slap on the wrist. Marcia, let's hone in on that about the law. Nobody should be above it. It's a great equalizer. Right? Your thoughts on that comment?
It is a great equalizer, but we have to take into consideration the totality of the circumstances. These are misdemeanor charges that Mr. Katz is faced with. And when you look at it, the state could go forward without using a video or without violating anybody's constitutional rights in order to be able to convict him. There's testimony, officers could testify to it. So he can still be punished. It's just that the punishment is going to have to fit the crime. And when you're looking at misdemeanor, the maximum he could be facing on each count is going to be 12 months incarceration.
Right. Thank you for pointing that out, Marcia. Peggy, she writes, quote, yes, if it shows that he was there and it could prove what police has said that happened. But on the other hand, he will get his way because money talks. Okay, so Peggy's saying essentially, yeah, it should come in. It's proof. Judge, what do you think about that? Agree or disagree there?
Well, again, that's someone who is disregarding what the law is, because just because you've got evidence that can prove a crime, if it's illegally gained, then you can't use it at trial. And lay people don't always understand that, and they can be frustrated by it. But I think if you take the time like we have tonight to explain that these are constitutional protections, that if the court stands up and says, no, you can't do that, then that benefits all of us in society.
I'm so glad you mentioned that, Judge. Yeah, oftentimes, what comes in as evidence, is dictated by how it was obtained, legally or illegally. And just because police got it doesn't mean they got it the right way necessarily. That's why all of you wonderful criminal defense attorneys are so important. And what we want to do now, because we heard from the prosecutor, want to be balanced here always, let's listen to some of what the defense said today in that hearing.
Law enforcement realized early on, in Mr. D'Souza's words, in the calibration period, that, wow, we have this problem. We are seeing women engaging in illegal massages, they're disrobing, and we're recording them. And I'm concerned that we're recording them. So even though they didn't know Mesa Rincon, even though they may not have understood the legal terminology of minimization, they still knew something was wrong about recording women engaging in innocent conduct, recording those women while they were naked. So they actually went to the state attorney in this case. And they said, hey, tell us what we should do. Should we not record at all in this situation, and we may miss out on 1 or 2 men engaging in allegedly illegal activity, but then at least we won't record the female engaging in clearly legal activity, or should we record everything? And what did the assistant state attorney say in this case? Record everything. This was not just a blatant disregard. This was an intentional disregard of the only bolded language in this order that said you must minimize. And as a result, what happened? We have recordings in the Indian River case of 4 women who were engaging in legal massages, getting undressed, and those recordings exist today. They have not been erased. They are on a server in the sheriff's office computer files. And even worse, this recording was disseminated into the community. One of the defense attorneys asked for discovery, and the state complied and sent out a video of the recordings. And the defense attorney started watching the video, and lo and behold, here's a female getting undressed, recorded, and the recording covers her entire massage. So the defense attorney in that case immediately brought this matter to the attention of the state attorney's office, and that's how we know that the state failed to minimize.
And we will have to stay tuned to see what the appellate court decides and whether this case proceeds or essentially goes bye-bye. And because of the time, we're going to have to say bye-bye now here on Court TV Live. Many thanks for all of those wonderful 13th juror comments, and big thanks to our impressive think tank tonight. Attorneys Marsha Minot, Brian Watkins, and Judge Phyllis Collins, thank you so much for lending us your expertise on the program.
Thank you.
Thank
Thank you.
I'm Julie Grant. It has been great being with you tonight, filling in for Vinnie Politan. And as my friend always closes his show, don't forget to hug the kids. We'll see you tomorrow.